All right, welcome, folks. We are going to wait just a little bit and for some other people to join us. All right, we are going to go ahead and get started today. Thank you, everyone, for joining us for the Brooks Pierce Labor and Employment webinar today. Our topic is employee classification laws in transition. And I'm going to let our lawyers today, Beth Langley and Erin Barker, introduce themselves.
Cecilia, thank you so much. Great to have each of you with us. I'm Beth Langley. I'm one of the labor and employment attorneys in our Brooks Pierce team, and I want to introduce my colleague, Erin Barker, who also practices with us in labor and employment as well as employee benefits. So we will have at the end of the session today, the SHRM code for those for whom that's applicable. And also please feel free to ask questions along the way. If you'll put those in the chat box, that would be great. When you ask a question, we would ask that you not include confidential information about your organization. Just have a generic sort of inquiry, because we certainly don't want to disclose anything confidential. And then finally, by way of introduction, our intros, just let you know that we will email you all these presentation materials. That most likely it will be tomorrow or no later than Wednesday. And in those materials, the SHRM code will be included as well. So Erin, I'm going to turn this over to you to get us started.
Great, thanks, Beth. As Beth said, I'm Erin Barker. I'm also a labor and employment attorney and also work in the employee benefits sphere. Today, we are going to talk about several different arenas of employee classifications. So we will start with some issues in Department of Labor, wage and hour, exempt versus non-exempt classifications, and what comes up in those investigations. We're going to cover the proposed 2022 Department of Labor independent contractor classification rule. We'll also talk about the proposed NLRB Joint Employer Rule, and then finally, joint employer liability in the Title VII context. All right, with our general reminder here, this is general information. We are going to talk about a lot of different regulations, but we're not going to be able to get into the details of every single one, and there's a lot of nuances. And as always, it's a very sort of fact by fact, circumstance by circumstance question as to what an employee is classified as. So this is not legal advice, and if you have any questions, you should consult with an attorney, and we're happy to talk to you individually about your sort of unique circumstances. But as Beth said, if you have any questions about your specific facts or circumstances, please feel free to reach out to us separately, and please use the chat box for any sort of general questions you have. Also, the proposed rules we're going to talk about are just that, proposed. They're not yet final. There could be changes. There could be some slight adjustments to the proposed rules based on comments that the public submits. So as those final rules are published, we will be keeping an eye out for them. We'll probably publish some sort of alert on them, but the information in this webinar may become outdated as those proposed rules are finalized.
Thank you, Erin. Yeah, we, in selecting our topics today, we really focused on what activity are we seeing as employment attorneys from government agencies. And we're focusing today at the federal level. And the first statute that we want to talk about, where there are some proposed changes, is the Federal Fair Labor Standards Act. And particularly, this has to do with classifications of employees. So what we're going to cover today is kind of the current state of the law. This is going to be the one area where we're talking about not a proposed rule, but how things are now. There is some activity at the U.S. Department of Labor level with discussions about potential changes to the Fair Labor Standards Act regulations. But we're talking again about the state of the law in the end of November of 2022. So what we're seeing is an uptick in U.S. Department of Labor wage and hour investigations. And we wanted to cover the issues that we're seeing most often the federal investigators looking into. And so the first area in this wage and hour piece is who is exempt and who is non-exempt. And let's kind of start off by what those terms mean. So most employers in the United States, there are a minute exceptions. Most employers are covered by the Federal Fair Labor Standards Act. And the Fair Labor Standards Act covers minimum wage and overtime requirements. And every employee who is supposed to receive minimum wage, at least minimum wage at the federal level and overtime, is a non-exempt employee, meaning you're not exempt from the requirements. Everyone else is exempt. And we're going to talk about what those some of those most common exemptions are. So the exemptions, and Erin, you can move to the next slide. The employees who are exempt, meaning again, the employer is not required to pay minimum wage and overtime. Those common exemptions are, we've kind of listed below. Executive employees, often called the managerial exception, the administrative exemption, professional employees. We'll talk a little bit about what that means. Computer professionals and outside sales employees. And as in a bit, we're going to get into exactly what those requirements are. But these are, when we talk about the exemptions, these all have legal definitions as to what those specific categories of exempt employees mean. We often find that there is a misconception out among business people, frankly, that if you pay employees on a salary basis, you don't have to pay them overtime. And this is where the minimum wage issue comes into play as well. Because if someone is just, you put them on a salary, but they really should be paid overtime, all of that time, if an employee files a wage and hour complaint, or if there is a impromptu investigation, the burden is really on the employer to produce records that the employee has been paid at least the minimum wage and for all hours worked, overtime for all hours worked over 40 in a work week. So just labeling someone's salary does not render them exempt from the minimum wage and overtime requirements. So specifically, there is a presumption that employees are entitled to receive overtime for all hours worked over 40 unless they meet a specific exemption in the federal statute. And it doesn't matter whether you pay them salary, hourly, or otherwise. There is a presumption that they're entitled to overtime.
All right. So as Beth said, just because someone's paid salary on a salary basis does not automatically make them exempt. But a salary basis is part of the exemption. So we're going to talk about the requirements to meet one of those tests for exemption. And there's really 3 tests here. So, and you have to meet all 3 of them for the employee to be exempt. First is the salary basis test. So that is where the employee must generally be paid on a salary basis. There's the salary level test, and that is that the employee's salary must meet a certain threshold amount. And then there's a duties test. So for each exemption, there are different duties, and the employee's primary duties must meet certain criteria. And so we're going to talk about a few of those duties. But we're going to start with the salary basis test. So the salary basis is defined in the regulations, and an employee is paid on a salary basis if they regularly receive each pay period on a weekly or less frequent basis a predetermined amount constituting all or part of the employee's compensation, and that amount is not subject to reduction because of variations in the quality or quantity of the work performed. So that's a pretty, wordy way to say that it's a salary basis. If it's a predetermined amount, it's paid weekly, it's not dependent on quality or quantity of production, and it's not going to have deductions based on the quantity or quality of production. Recently, there's a case that is kind of throwing this into question of what is a salary basis and what's a weekly basis. There's this case, Helix Energy Solutions Group Inc. versus Hewitt. This is recently argued before the Supreme Court, and the question before the court is whether an oil rig worker was wrongly denied overtime pay. There was no sort of argument that the worker did not meet the duties test, so they satisfied the duties test of the executive exemption. They definitely satisfied the salary level test, so they were paid over $200,000 a year. But the issue is they were paid on a daily basis. So they were paid at least $963 per day, which added up equaled over $200,000 a year. And they were paid bi-weekly, but based on this daily rate. And so the question before the court is, does this daily rate satisfy the salary basis test? And so we are keeping an eye out for the answer to this question, and are interested to see whether a daily rate will count. Next, we have the salary level test. This is the minimum. So Beth said earlier that if an employee is exempt from the FLSA's minimum wage and overtime requirements, that means the employer does not have to pay minimum wage or overtime. But the employee's salary must be at least $684 per week. And so typically that will get the employee over minimum wage on an hourly basis, but we're looking at a weekly salary here. For computer professional employees, they could be paid hourly so long as it's $27.63 an hour, but that only applies to the computer employees. We are also waiting to see if this $684 is going to change. There's been some discussion at the DOL level about changing this requirement, and so there is a pretty high probability that we will see a revision to this salary level test in the near future. So we are also keeping an eye on that. All right, so the duties test, and this is where we get into different duties based on each exemption. So the duties are not the same for all exemptions, and as a reminder, these duties are based on each individual employee. They can't be based on just job description. You have to look at every single employee to see whether or not they meet the duties test. So for the executive exemption, also known as the managerial exemption, the primary duty must be management of the business or a department or subdivision of the business. Management includes interviewing, training employees, setting and adjusting rates of pay and hours of work, directing the work, maintaining production or sales records, evaluating employees and appraising their productivity and efficiency, recommending promotions, handling complaints from employees and grievances. Discipline is included here. And this is really sort of when you think of a manager, like someone who is really in charge of a department or a subdivision or the business as a whole. These are the sorts of duties that come into play. This employee must also customarily and regularly direct the work of at least 2 or more other full-time employees or their equivalent. Customarily and regularly means more than occasionally, but not constantly. So generally we look at sort of a weekly basis to say, is this happening more than an isolated or one-time sort of task or management? 2 or more other full-time employees, if you think about, part-time or a half-time employee, 2 half-time employees equals 1 full-time employee. So you kind of count out what the equivalent is. And then finally, the employee must have the authority to hire or fire other employees. Or if they don't have the ultimate authority to do so, their suggestions and recommendations are given particular weight. And so particular weight doesn't necessarily mean that they are the end all be all, they have the final say, or that their recommendation is always listened to, but it does mean that, that recommendation is considered and that they give suggestions, and oftentimes those suggestions are followed through with, or, it's these employees are the ones that this manager is supervising and they're making decisions about those particular employees. Next, we have the administrative exemption. The primary duty here is the performance of office or non-manual work directly related to the management or general business of the employer or the employer's customers. So instead of management, like the executive exemption, this is sort of the office work that directly relates to the management. The sorts of things that are covered by this duty includes tax, finance, accounting, budgeting, auditing, quality control, purchasing, advertisement, marketing, research, safety and health, other personnel management, a lot of human resources duties, employee benefits, labor relations, government relations, and so forth. The employee must also exercise discretion and independent judgment with respect to matters of significance. So discretion and independent judgment means that this employee is looking at all the options and deliberating on them and considering all the different courses of action, and then making a decision as to what that course of action is going to be. So there's an implication here that employees who meet the administrative exemption have the authority to make an independent choice and don't necessarily answer to a direct supervisor or have any sort of oversight as to that decision. And then matters of significance don't just mean monetary significance. It could be significance as to the operations of the business as well. Next, we have the duties of, this is the learned or learned professional exemption. There are a few different professional exemptions and they sort of have different duties. So here we are going to focus on the learned professional. The duty must be the performance of work requiring advanced knowledge. So this is going to be intellectual work. It involves exercise of discretion and judgment. It's typically going to be distinguished from sort of routine work that doesn't require any sort of independent thought. It's usually going to involve those action words like analyzing, interpreting, evaluating, and the regulations are clear that advanced knowledge cannot be attained at the high school level. So the advanced knowledge must be in a field of science or learning. This includes fields like law, medicine, theology, accounting, engineering, architecture, pharmacy, physical, chemical, and biological sciences, and more. And the advanced knowledge must be customarily acquired by a prolonged course of specialized intellectual instruction. So this is where we get into, it can't be, a high school level. It's typically going to be an advanced degree, but it doesn't necessarily have to be a doctorate. Next, we have the duties for the computer employee. The computer employee must be employed as a computer systems analyst, a computer programmer, a software engineer, or other similarly skilled worker in the computer field. So there are 4 primary duties, and it can be any combination of these. So it could be applications of systems analysis techniques, including user consultation, determining hardware, software, system functional specifications. So that's where you might think of a systems engineer. The design, development, documentation, analysis, creation, testing, or modification of computer systems or programs. So this is going to be more like the software engineer. Design, documentation, testing, creation, or modification of computer programs related to machine operating systems, or a combination of the above. So this is really sort of the advanced computer skills. So typically we might see everyone in an IT department classified as exempt under the computer employee exemption. But then if you look at the duties and the employees are just sort of following a troubleshooting guide and not actually applying any systems analysis techniques or designing or developing or creating any of the software, they might not meet the duties tests for the computer employee exemption unless they're doing some sort of combination of work. And just
Erin,
as a reminder,
I'm sorry to interrupt you. Can you address that issue like when they're like, say, an IT help desk role?
yes. Yeah, so an IT help desk role, sometimes an employee is only working in an IT help desk role. And an IT help desk role sometimes will just involve specific troubleshooting steps, like, the user, the customer will call, and it's, 24/7 help desk hotline. And then that person on the other side of the phone, the employee, has steps that they have to follow. Say, okay, have you tried turning the computer off and on again? And does that work? And if not, then sort of following these rote steps. And that doesn't really involve any sort of skilled computer science or analysis skills. And so what we're looking for here to meet the computer employee exemption is more like the software engineer or the customization roles. Like instead of a help desk employee, you might have an employee whose job it is to consult with the customers and customize the software to fit their specific needs, or to figure out, the company is selling software and this employee's role is to get on with the customer and analyze what hardware they currently have and tell them if they need to upgrade their servers or upgrade their hardware to run the software efficiently, or sort of go in and, actually use analysis skills to troubleshoot a problem instead of just sort of a rote if then guide that's already predetermined for them. They're actually going in and using analysis and evaluation skills based on their knowledge of computer systems to go in there and check it out. Oh, and before I move on, I was just going to say a reminder that the computer employees are the ones who can be paid the $27.63 per hour instead of the weekly for the salary level test. All right, next we have outside sales. The primary duty for an outside sales employee to meet the exemption is making sales. But of course, sales is defined in the FLSA. So sales includes sale, exchange, contract to sell, consignment for sales, shipment for sales, or other disposition. It's the transfer of title to tangible property. And in certain cases, it's transfer of tangible and valuable evidences of intangible property, such as software, or obtaining paid orders or contracts for services or for the use of facilities. So it's not just the sales of goods. So it could also be the selling of time on radio stations or television programs. It could be solicitation of advertisements for newspapers or periodicals and so forth. And the bigger sort of issue that comes up is this second requirement in the duties test here, which is that they must be customarily and regularly engaged away from the employer's place of business, meaning that they should be making sales at the customer's place of business or home. And this got kind of muddied up in the last couple of years because, as most of you are probably aware, people worked from home a lot in the last couple of years. There was less travel to go make sales. People weren't flying across the country every day to visit customers and make in-person sales like this exemption really requires. And it hasn't really been addressed very clearly whether someone working during COVID times could still meet this exemption if they weren't actually traveling to the customer's place of business. The regulations specifically exclude sales by mail, phone, or internet, unless it's just auxiliary to an in-person sale. The classic example here are door-to-door salespeople. And again, it got more complicated during COVID when we weren't really knocking on people's doors or knocking on customers' doors. So that's sort of something that we're also keeping an eye on, is whether that comes up and whether the DOL is going to sort of make a fuss about it in any sort of investigations arising out of the last couple of years. All right, another common exemption is highly compensated employees. Highly compensated employees are those who are paid a total annual compensation of at least $107,432 or more. This has to include that at least $684 per week paid on a salary or fee basis. So we'll wait to see what the Helix case comes out with, but right now it should still be at least a weekly salary. The primary duty is going to be office or non-manual work, and they have to customarily and regularly perform at least one of the duties of the previous exemptions. So at least one of the duties of an exempt executive, administrative, or other professional employee. And of course, customarily and regularly means not isolated, not a one-time task. It's going to be pretty much on a weekly basis. All right, another common exemption is commission sales employees of retail or services establishments. These are employees who are employed by a retail or service establishment. So that is an establishment engaged in making sales of goods or services, and at least 75% of its sales of goods or services or both is recognized as retail in the particular industry. And then not more than 25% of its sales are for resale. So retailer services establishments are those that we think of as providing services for the comfort and convenience of the public. It's daily course of living sort of businesses you might see, such as repair services, food and drink providers, furniture sales, car dealerships, hotels, restaurants, barbershops, clothing stores, hardware stores, sort of those general stores that everybody has access to. But it could also be sales to other businesses. So it can also cover some commercial sales. The employee's regular rate of pay here must exceed 1.5 times the applicable minimum wage for every hour worked in a work week in which overtime hours are worked. So this is sort of, you're exempt from paying overtime, but they're essentially making overtime for every hour they work if they're being paid 1.5 times the minimum wage. And then more than half of the employee's total earnings in a representative period must consist of commissions. And this is where some issues come up, is when you look at that representative period, it can be as short as 1 month, but not greater than a year. And you look at their earnings and you have to really carefully calculate whether more than half of those earnings are commissions. So that takes some math, and it takes going back through those representative periods, whether it's the month or the whole year, or if it's a 6-month period where commissions are earned, and saying, okay, was more than half of the pay commissions? If not, they're not going to meet this exemption. And then here we have a list of a few other common exemptions that we see. We have farm workers employed on a small farm, sales partsmen and mechanics employed by automobile dealerships, employees employed by certain seasonal amusement and recreational establishments. So those are typically, think an amusement park that's open for half the year is going to be the common example of that one. We have teaching professionals, and then creative professionals. And creative professionals are those who do work that require invention or imagination or originality in an artistic or creative field. So that's going to be actors, musicians, music composers, soloists, some painters, writers, novelists, and so forth.
Thanks, Erin. I really appreciate all the detail you've gone into. I think if there is a kind of nugget to glean, is that determining whether a role is exempt or not is very fact specific, and it's very much married to both the regulations and also USDOL does from time to time provide us opinions on, someone poses a hypothetical situation, and DOL will provide some guidance on that. But it's costly to come down on the wrong side of whether an employee is exempt or not, especially if it's more than, if you have several people in the same role and it ends up being misclassified. And we wanted to give you some examples of just some recent activities by USDOL. If you go on their website, there are screens and screens of these results. But just in this month, USDOL published the findings of an initiative that it had engaged in over recent months, and determined that 80% of there were violations for employees, and 80% in what they called care industries, which was really broadly defined. So that would be healthcare, home health care, personal care. If you have a personal nanny, those roles where someone is caring for another person, 80% of those roles have some sort of wage and hour violation, whether it's a misclassification or not paying overtime properly. And the DOL has assessed $28.6 million in recovery for 25,000 workers. So keep it in mind that recovery for an employee who can show, or if the DOL can show on their behalf, a violation, there's back wages for up to 2 years, 3 years if it's a willful violation. There's interest at the federal rate. And in addition, and this is where it really gets pricey, the statute provides for liquidated damages, which is double the amount of the underlying back wages. And if wage and hour division determines that this was any kind of willful, or if it's a repeat violation at all, then civil monetary penalties are assessed, and those are very, very costly. Another recent press release from USDOL relates to a company that's near and dear to many of us from here in North Carolina. Krispy Kreme is to pay more than $1.1 million to over 500 workers, because in this situation, Department of Labor took the position that Krispy Kreme had not properly calculated overtime, because there's a term called the regular rate of pay. So in any work week, you have to determine all of the non-discretionary payments that the employee receives. And in this situation, Krispy Kreme had not included the non-discretionary bonuses. We saw bonuses become a big issue, especially during COVID, and we now see it with this tight labor market where employees are receiving, sign-on bonuses, which is non-discretionary, performance bonuses if you remain employed for X amount of time or you hit certain triggers. Those are non-discretionary bonuses that have to be factored into an employee's regular rate of pay. So not just their hourly rate, to determine what their overtime compensation should be. And this really adds up when you're looking at several employees. So our recommendation is that this is a really good time to go back and take a look at your organization's classifications. And here are just some of the, we would call them red flags, that where we see DOL focusing their time and efforts. If you're an organization that for some reason it's just said everybody's salaried and nobody's going to receive overtime, that would be a red flag. Also, if you have a situation we've seen where employees that would otherwise be exempt are being paid on an hourly basis, that will destroy the exemption. And those employees who may be very highly compensated will be entitled to overtime. Those hourly equivalents, the hourly wage at 1.5 times really adds up. So think twice before putting someone who would be exempt on an hourly basis. Not paying for on-call time, that's on-call has its own definition. We'll be glad to get into that. Inside sales and assistant managers and IT roles are three that get a lot of scrutiny. from USDOL. So be very careful. We're seeing right now a lot of collective actions on behalf of employees in designated roles such as assistant manager. A collective action is in essence a class action filed under the Fair Labor Standards Act. Another area to take a look at is human resources roles, other administrative roles. Not every position in those departments are going to be exempt. I mean, just because you're in marketing or in HR does not mean necessarily that your role is exempt. And that administrative classification is a really tricky one because it doesn't mean administrative assistant or administrative task. It really means much higher level. We're seeing also close scrutiny on tip pools. The tip pool rules have changed several times in the last years, but key points to keep in mind is that management employees cannot participate in the tip pool. Non-servers cannot be in the tip pools. And there's certain industries that are just getting some more scrutiny right now, some heightened scrutiny. Hospitality in general, construction, agriculture, healthcare. We're seeing a lot of activity in those industries. So, Erin, how about talk to us about the classification of who is an employee versus who is an independent contractor under the Fair Labor Standards Act?
Yeah, so we have talked about the exempt versus non-exempt employees under the Fair Labor Standards Act, but there's sort of a different question of classification when it comes to who is an employee versus an independent contractor. So here we have a new proposed rule that came out this year within the last couple of months that we are keeping a close eye on. But we're going to go into some background first before we get into that rule. So pre-2021, when you look at whether someone is classified as an employee or an independent contractor, it was a totality of the circumstances test. And what that meant for us is that, it was a very fact-intensive analysis of, okay, we have to look at all these different factors and determine whether this person is an employee or an independent contractor. And as factors, we're looking at the economic realities of the situation, of the working relationship. And those factors included the extent to which the work performed is an integral part of the employer's business, whether the worker's managerial skills affected his or her opportunity for profit or loss, the relative investments in facilities and equipment by the worker and the employer, the worker's skill and initiative, the permanency of the relationship, and then the nature and degree of control. So we would often think about this test mostly coming down to control. Sort of all of these factors have something to do with who is in control, who is controlling sort of the equipment, who's responsible for the equipment and the facilities, who's controlling the hours worked, who's controlling the schedule, is the worker just responsible for the finished product and that's all the company cares about, or is the company also overseeing the methods and means of the work? So those were sort of the questions we were looking at. In 2021, a rule was published that limited those factors. We still had all the factors at play, but really there were two core factors. It was the nature and degree of the worker's control over the work and the worker's opportunity for profit or loss. So you would look at these factors, and if they both came out the same way, that was the answer. If they came out different ways or it wasn't clear, that's when you would sort of start going back and looking at the other factors. But this test in the 2021 rule really made it easier for someone to be classified as an independent contractor. Once you start limiting the factors, it gets less sort of wishy-washy and less sort of it depends, and you're really sort of looking at just two core factors here. Now 2022 comes around and we have a new proposed rule. So the proposed rule was published on October 13th. A proposed rule is open to public comment for 45 days. So that was until yesterday, November 28th. And we are expecting to see a final rule coming soon. We don't know yet whether it will be identical to the proposed rule or whether there will be any changes based on the public comment. But we are certainly keeping an eye on that and will most likely be publishing an alert that will go out once a final rule is published. Now, the proposed rule does include details. So the proposed rule is published online. You're able to find it. We also have a client alert about the proposed rule that links to it. It goes back to the multi-factor totality of the circumstances approach. It rescinds the 2021 rule. It clarifies that no one factor or set of factors will have a predetermined weight. And so it's really up to whichever, court or entity is looking at it to weigh those factors and figure out, is this a person, an independent contractor, or an employee for purposes of the FLSA. The factors here include, back to pre-2021, we've got opportunity for profit or loss depending on managerial skill. The investment in the facilities and equipment was adjusted a little bit for this new rule to be the worker's capital or entrepreneurial investment in relation to the employer's investment in its business. So this isn't just looking at equipment, it's also looking at capital investment. We have the degree of permanence of the working relationship between the parties, the nature and degree of control over work, and specifically including scheduling, supervision, price setting, and whether that worker is able to go work for other people or if they are just working for this one company at this time, the extent to which the work is integral to the employer's business, and the skill and initiative involved in performing the work. And then there's also a note in the proposed rule that additional relevant factors may exist in some circumstances. So there might be some circumstances that come up where courts would be able to look at different factors as well and weigh them in the analysis. So what this means for employers and for companies is that it's a good time to look at those current contractual relationships with independent contractors and look at those classifications and start evaluating, is this going to fly under the new rule? The proposed rule is, according to the DOL, meant to protect employees' rights, which means that it's probably going to be more difficult to classify workers as independent contractors. So it's trying to sort of pull more workers under the umbrella of federal labor standards and protect their rights rather than allowing them to be independent contractors who may not be subject to overtime pay or other federal labor protections. So it does potentially increase the risk that workers who are currently independent contractors will suddenly become employees. Of course, there's going to probably be challenges to the new rule, as there always are. There's going to have to be interpretations of the rule, but this is sort of the time to take a look and say, okay, how much control are we exerting over this worker? Are they investing in the facilities, the equipment, capital investments? Do they have their own business? Are we setting their schedule? Are we sort of setting the methods and means that they're using to do the work? Or are we hiring them to just complete a task and we don't care when or how it gets done? So now is sort of the time to go back and evaluate those classifications. And then Beth is going to take it away with the NLRB proposed rule, which also came out recently.
Thank you, Erin. I think many of you may be asking yourselves, why do I care about the NLRB? And so part of that is we want to let you know why. The NLRB cares about you. I think there's been a belief out there that the National Labor Relations Board really just applies has jurisdiction over unionized workplaces. And that is not the case. The National Labor Relations Act, which is implemented by the National Labor Relations Board, governs all employers, with the main carve-outs are state and federal employees. So except for the post office, but what we are seeing, and this is very cyclical, but in this current season, what we are seeing is increased activity by the National Labor Relations Board of finding unfair labor practices against non-unionized employers. And where this really, we're seeing activities such as in NLRB finding violations of the statute because of how handbooks are worded, how confidentiality provisions are worded. Last week, they came out with a rule about proposed guidance on surveillance of employees, which means, it doesn't mean that you're spying on your employees, but some regular practices that many companies have, such as monitoring computer activity, monitoring comings and goings from work, and they're taking the position that that activity to some degree may be an unfair labor practice. So this is why it's important, and what we're seeing from this proposed rule by the NLRB is a broadening of the concept of who is an employer. So also going back to give, just as Erin did, I want to give you a little bit of history on where the board has gone with this. When I say the board, the NLRB. The NLRB is composed of 5 board members. All board members are appointed by the president, and they have 5-year terms. So each year, someone's coming off the board, somebody's coming on, the president appoints those members. And so what we see are trends and activities by the board based on who's in the White House. This is not to be political, this is just how it is. So if we go back to 2015, there was a case called at the NLRB called Browning Ferris Industries. And the issue in that case is who was the employer? Was there a joint employer relationship, or was only the so-called operating company the employer? And this case went up on appeal because NLRB cases are appealed to federal circuit courts. And while that case was on appeal, in 2020, a new NLRB board, or a board comprised of different members, issued a different standard of who was a joint employer. And under this new standard, the board in 2020 said that an entity must have actual and direct immediate control over the essential terms of an employee's employment. So what that means is, let's take the example of a temp agency that is assigning workers to a customer. The customer must, who's paying for that temp worker, under that 2020 rule, that the ultimate customer would only be a joint employer if that customer exercised direct and immediate control over how much the employee was paid, the work hours, and discipline. That's sort of your classic example of when there's a joint employer. Whereas in the Browning Ferris standard, if there was reserved authority, say if the customer said, you know what, I reserve the right to kick anybody off of our work site, or I am going to, the customer, control quality, that would be indirect and reserved authority. So if we fast forward now to 2022 and the proposed rule, in September of this year, the NLRB issued a new rule with a proposed standard. It's still pending. Interested parties can still file comments until next week. That is extended from November. And pretty much what the proposed rule is going back to the Browning Ferris standard with a bit more detail. So, for example, 2 or more entities, employers, would be joint employers if they can either share or they co-determine those terms of employment. And evidence that will be relevant is both if there is direct control, you have a supervisor on site who's setting a schedule and determining wages and hours and quality and that sort of thing, or if there is that reserved or indirect control that I spoke about earlier in that Browning-Ferris case. What we're seeing is that actually a stated intent by the NLRB to expand the definition of who is an employer. So think about situations like where there's a franchise relationship, where there is a parent company relationship, a lot of times contractual relationships. Think in an agricultural setting. Erin and I were talking about this one yesterday, where you have growers who have a contract with a particular distributor or manufacturer, say it's in livestock or produce or something like that, where the actual standards of operation are being set by contract. There very well may be a joint employer relationship. Same with the franchise. When you think some of the franchise agreements have such strict requirements on, how an employee dresses, how the operations are going to be conducted by employees. NLRB very well may come in and decide that that's a joint employer situation. And the implications for that are that, if you're the employer, then it's your obligation to ensure that all aspects of National Labor Relations Act are complied with. So for instance, if an employee alleges, I was fired because I talked about my wages, and the NLRA says employees can join together and talk about their work conditions. The franchise owner may ultimately be held responsible as well for that unfair labor practice violation. In the union setting, then both could be subject to union picketing, both could be required to bargain with the union. So it's an enhanced jurisdiction, if you will, of the National Labor Relations Act. And it's just something to be really aware of, especially if you have like management services agreements with affiliated entities and or you have a lot of employees through temp agencies. You very well may be determined to be a joint employer. And the final federal statute we want to talk about in our remaining time is under Title VII. And when we think about this, we're also just go ahead and assume that we're talking about the Americans with Disabilities Act as well, and those other statutes that are administered by the EEOC. Quite often, this issue comes up. Say if there's an EEOC charge and you have someone who's maybe working for an operating entity, but then there is an affiliated entity that has some sort of control, or maybe an affiliated entity is the W-2 employer. The question is, who is the employer for purposes of liability under Title VII or these civil rights statutes? So, Title VII, just as a reminder, prohibits discrimination on the basis of gender, race, sex, national origin, religion. It's broad. It covers all employers with 15 or more employees, full-time or part-time. So in this context, what the EEOC is looking at is they want a broader scope to determine there may be two employers who are responsible for any violation of Title VII, especially for purposes of determining damages for the employee if discrimination is proven. And where we look for our guidance are the federal courts who have jurisdiction within the area in which the employers operate. So for our purposes, we're relying on the Fourth Circuit Court of Appeals. The Fourth Circuit has adopted what's called a hybrid test. So Erin talked earlier about the control test and the economic realities test. This hybrid test is sort of a combination of both that our federal courts in at least our region are looking at to determine whether or not there is a joint employment relationship in a particular situation. And these are some of the factors that the court looks at. Who has, again, authority to hire and fire, looking at day-to-day supervision, the equipment, is one particular company like providing the forklifts and the manufacturing facility, whereas someone else is another company is just the one providing the paycheck and payroll services. There very well may be a joint employer there. Is this an employee assigned only to one particular entity or several within an organization group, a corporate group? You kind of look at that control test. You look again at how long someone works there. Look at, for instance, in a temp agency situation, do you have someone who's just there for a day, or is it a more prolonged? And again, none of these factors on its own will control the day, but it's really looking at the whole totality of the circumstances, applying sort of these hybrid factors. So again, those are issues to kind of keep in mind. You may have contractually an agreement that says these are not my employees. That's not going to rule the day when it comes to either the EEOC or the courts. It's going to be fact specific. You may have a contractual maybe indemnity or contribution claim, but it would not determine whether someone is legally an employee with one or more entities. So at this time, we would be glad to address any questions that you all have. We also want to just encourage you, if you have follow-up questions, because this is a lot of information, feel free to reach out to either me or Erin, anyone on our Brooks Pierce team. We'll be glad to answer any questions you might have. Again, as Erin said, this is an evolving area of the law as we're seeing a lot of activity at the agency level, and we'll keep you updated as we get more developments. We'll send them your way as well.
Absolutely. And like Beth said at the beginning, we will be sending out this recording as well as the slideshow. And so this information will be available to you, but as a reminder, it's all fact specific, and we are happy to answer any questions you may have, whether it's general in the chat box or a more individualized question that you want to reach out to us or another member of our labor and employment team. We are always happy to help. We'll give a minute for questions, and then in about a minute, we'll, if there aren't any questions, we'll be stopping the recording and sharing the SHRM code for you too, if you would like to get SHRM credit.
Well, thank you all, everybody. We've really appreciated you participating with us today. And Erin, you would have to tell me, I know we're going to have upcoming webinars in 2023. We've not published our schedule yet, but stay tuned and we'll keep you updated. If you have other members of your team who you would like to have included in our email list that goes out with our legal alerts and notices of our webinars, just please send them to either me or Erin, and we'll make sure that contact information is included.